Thank you very much, everybody, for the short introduction of my shady past in the area of the old third pillar, and I too I'm very happy to see so many so fresh in spite of the excellent hospitality we enjoyed last night. I'm going to address you on the subject of mutual recognition and the relationship with fundamental rights on the basis of the Dublin regime, and I will, bearing in mind the play of Oscar Wilde on the importance of being earnest, I will be, in spite of the fact that I'm not called either Ernest or Frank, I will be honest and say it's not easy to cover everything in this area in the 30 minutes allocated to me, but I will give it a try. You know that the Dublin regime stems back from the Dublin Convention, which was signed, I was actually in the room when it was signed at Dublin Castle on 15th of June 1990. But even then it was already carved out of the Schengen arrangements and lifted as a first thing from the level of the smaller group of Schengen countries and made into a European arrangement, but completely outside of the treaty arrangement in place at the time, because that was even before Maastricht, which was the point when really asylum, together with other areas of immigration law, police cooperation, border controls and stuff, entered into the treaties, but then in the third pillar. And then gradually it has traveled via notably Amsterdam and then Lisbon from the third pillar into a special chapter, still retaining some intergovernmental features into the first pillar, and then further on into becoming essentially fully integrated in union law by the Lisbon Treaty. So meaning, if not, but at least when the transitional regime will expire by late 2014, then we will have something which is perhaps not fully, completely, in every detail, a one shop for everything, but something that comes pretty close to it when we are looking at judicial controls of decisions in this area. So we will then have and have had for quite some time something that comes pretty close to a real competence at the Court of Justice in the area of the Dublin regime. And of course it's not for us to make the laws, it's for us to interpret them. That is quite clear. But I say this and I stress this because we are sometimes accused at the court in Luxembourg of taking the legislator's role and actually develop the union law in a way which is perhaps too dynamic and not leaving that to the legislator or the legislators in Brussels. We, on the other hand, in Luxembourg tend to see it slightly differently. I think I can there speak contrary to what I would perhaps otherwise say, which is solely on my responsibility, but I think in this area we're quite in agreement, all of us, that we would absolutely prefer if the EU legislator expressed the legislation in a more clear and more complete fashion, because that would certainly facilitate our task later on in interpreting the law. But on the other hand, and given my shady past, I certainly understand why this cannot always be so. But then perhaps it would be nice for us if the legislators in Brussels remembered why one or another issue was expressed with full use of constructive ambiguity, or even deleted from the final instrument when it was adopted by Council and Parliament, and consequently the interpretation to be found in the future was left to the court. It is then, in a sense, a delegation of legislative powers in practice, when the court 5 or 10 years later, when the first case hit the court in Luxembourg, we will have then to fill in the blank spots in order to give national judges a useful reply that allows them to resolve the issues before them. But as a Danish minister once said to me when I expressed some anxiety that I was not absolutely sure what we had agreed on, said, "Don't worry, in 5 years' time when that will hit the court in Luxembourg, I will no longer be minister and you will no longer be deputy permanent secretary, so don't worry, be happy." The court has also, in the area of asylum law, had this chance with some delay to go in and interpret and clarify cases as they come to us. And of course, when you make the comparison with our court and say the US Supreme Court, we don't have the privilege of the American Supreme Court to pick and choose our cases ourselves. We have to deal with everything that comes through the door. Currently, around 800-900 cases a year. So we are certainly kept busy, and there is a tendency that matters comes in clusters, so that when the legislator has recently changed or adopted a new regime in a certain area, well, there's a delay for implementing it, and when that had expired, then normally in a couple of years' time the first cases start to come dripping from national jurisdictions, and we are given questions that we will have to reply to. That happened on the issue of ne bis in idem in Article 54 of Schengen. That happened to the European arrest warrant, and that has also happened in the area of asylum law. We have had, for instance, a number of cases. You will probably all be familiar with many of them on substantive asylum law, the qualification directive, B and D, Y and Z, X, Y and Z, and so on. And we have had cases also on the qualification directive on subsidiary protection, El Gafadji being one of them, and Diakite, where the judgment is still pending, but the judgment is announced to be delivered by the end of this month, on the 30th of January, interpreting the concept of armed conflict. So we have equally had a number of cases on the Dublin II Regulation, NS, Prit, Abdullahi, MA on minors, Castrati on the consequences of withdrawal of an asylum application, and the case K on the humanitarian clause. And again, I cannot go into all of these cases, but we'll focus on the NS, Prit, Abdullahi corner of the Dublin regime, also because it has something to say about the interplay on fundamental rights and mutual recognition. The key legal dilemma when we focus on this aspect is how far can or should authorities and courts in the requested country rely on the requesting member state, the requesting court, respecting fundamental rights. is it a possibility or is it even an obligation to scrutinize, to investigate, is this the case, is it okay, or is there a real problem? And there's perhaps also in this area, when it's discussed, there's also a political dilemma or political squeeze, because when you are asked to do something additional in order to protect notably a noble goods thing, a good value such as fundamental rights, it's tempting to say, yes, of course, we should add an additional control because it's so uphill to bring the arguments countering this fact. But there again, given my shady past, I think it's really important to remember that if you do install a system of full double controls, it means that you are essentially driving back European cooperation to a level that it left at least sometime during the 1950s. If you are to have effective cooperation, you need at least some level of mutual confidence. You have to up to a point, to rely on the other partners doing their job. But this is not without limits. And that is what was really clarified, I think, by the court in Strasbourg in the MSS judgment. Because there they did not turn down the whole system of mutual recognition. They did not annul or deny the existence of a presumption of coherence and the presumption that a member state, the requesting member state, respects its obligation. In fact, they recognize the existence of such a presumption, but there may come a point where the presumption is no longer valid, precisely because it is just a presumption. And the member state in the MSS case, it was Belgium and it was Greece that were being attacked before Strasbourg for violating the European Convention. Greece, because the material conditions of reception and the procedural way that Greece handled returned asylum seekers was not in accordance with the Convention. So Greece was eventually, at the judgment from Strasbourg, condemned for that non-respect of the Convention. But Belgium was also condemned, in spite of the fact that Belgium said yes, but we actually returned asylum seekers to the first country, to Greece, in full accordance with the Dublin regime. And Greece, like everybody else, have signed up to this. So how were we to challenge this? And this is not our task. Mutual recognition, mutual confidence. But Strasbourg did not accept that. Why? Because they said, well, but you are not allowed to turn a blind eye. You are not allowed to do what Admiral Nilsson did in front of Copenhagen, put the telescope before the blind eye and continue the bombardment of the Danish fleet because he wanted it to be completely destroyed, and because consequently he wanted to ignore the order to cease the bombardment. this is not a right for a member state to do so. If there are indications that there is a systemic failure in another member state at a certain period, at a certain given time, you are not allowed to turn the blind eye and ignore it because you think it's embarrassing or more convenient for you to do so and not go in and criticize the situation in another member state. And this line of reasoning has been adopted fully by the ECJ in Luxembourg. In the NS judgment, we accepted both the factual evaluation of the current situation at the time in Greece and took the consequence to say, well, in such a situation, you cannot return the asylum seeker to Greece because of the systemic failures in the situation in Greece. So the difficulty for judges, for national judges, but also in a sense for European judges, has for a period now not been what to do with asylum seekers that entered the Union via Greece, because it has been absolutely clear following MSS and NS that they cannot be returned for the time being to Greece. Of course, there will be, at one or another point, a difficult issue to find out because of all the efforts that the Commission and Greece are undertaking in order to improve the situation in Greece. When is it good enough to once again include Greece in the Dublin arrangement? But apart from that, there is another issue which is I think a difficult one still. When is the national judge supposed to take out the full toolbox from his cupboard with fundamental rights tools and examine in detail the situation in the member state? Well, Greece, it's easy because then you, at least for a while again, you know the answer. But what if an asylum seeker contests another country saying, oh, but I don't want to go to Finland, maybe it's dark, maybe it's cold, and they speak a strange language. So I think there's a systemic failure of human rights in Finland, so I prefer to go to another place. Is it necessary for the national judge then to take out the toolbox and examine it in detail and suspend the case before him for maybe many months while NGOs, international organizations, embassies, etc., are providing him with additional information on the current situation in Finland, probably with the result that he will be assured that yes, it's cold and they speak a strange language, but there are no systemic failure as such in their asylum system. But there could be other member states which at a given time are having difficulties because of a difficult economic situation, because of a massive influx of asylum seekers and other immigrants, legal and illegal, from various regions in the world, and where perhaps the answer is less obvious, and where a national judge will have to do something. And also there is the issue to what extent is this something that turns also into an individual right of the individual asylum seeker to bring it before a court and challenge essentially the application of the Dublin criteria, leading to a choice of a member state eventually to deal with his asylum request. And this linked issue was what was in fact at stake in the two cases fairly recently decided by my court by two different formations of the Grand Chamber, in the Puit case and in the Abdullahi cases. So if I use a little time on these two cases, I will start with the Puit case, which goes back and confirms what was already said by the Grand Chamber in the Ennis case, saying that when it is impossible to send back a person to Greece because of the systemic failures, well, what is then to happen? And in point 36, the concluding part of the Puit judgment, it is said very clearly, I hope and believe, that when there are systemic failures, systemic deficiencies in the system, and that means that an asylum seeker would face a real risk of being subjected to inhuman or degrading treatment within the meaning of Article 4 of the Charter, then that means that the member state cannot return him, the member state who has the asylum seeker and the asylum application, cannot return him to the member state with the systemic failures. That is pure NS. And then this member state is then obliged, it has the possibility to say, okay, then we'll do it ourselves. But they also have the possibility to just go ahead and apply the criteria, provided that this does not lead to too time-consuming and extensive a procedure, then to go through the other criteria to see if there's another member state that can be identified as subsidiary responsible member state. And eventually, going through these criteria, you will end in Article 13 of the regulation, implying that you will have to do it ultimately yourself. And again, if it leads to too long a procedure, well, you may be obliged to make the shortcut at an earlier stage. So that, I think, was a clear answer to the German judge about what was the situation on this case, this type of situation that was in the Puit case, a person that should not have been sent to Greece and now was back in Germany, and was challenging the way he had been treated and was seeking compensation. But it was perhaps a somewhat narrow reply and targeted, not dealing with every possible complication. And in Abdullahi, we had a more complex situation because there were more countries involved. Mrs. Abdullahi was a Somalian citizen who arrived illegally in Greece in July 2011, and after having traveled through several third countries and Hungary, she then arrived in Austria. And there she was arrested, and she then asked for asylum for refugee status in Austria. And the Austrian authorities then requested Hungary to take charge of Mrs. Abdullahi in accordance with the rules of the Dublin II Regulation. And Hungary accepted this request, and you would initially think then the case was, there was no case. But Mrs. Abdullahi was not happy to go to Hungary. They have maybe a strange language too, I don't know. But she challenged the decision before the Austrian court, saying, no, I want to stay in Austria and have my asylum application dealt with in Austria. And her reasoning was that given MSS and NS and the fact that before she, through third countries, arrived in Hungary, she had already had, in her view, the fortune of passing the Greek territory, where she, like everybody else, now knew there were systemic failures. So in her view, it followed from the logic of MSS that given the fact that she had been in Greece, then this systemic failure had already imposed an obligation on Austria to treat her asylum application itself. And that it's strange to me, somewhat strange reasoning, but it makes you reflect on the nature of the Dublin regime. Is this something? Yes, it's directly applicable. We know that it's a regulation, but is there something in the nature of the rules? They go back to a convention. They are primarily addressed to the member states, and it's for the member states to share the responsibility of dealing with the asylum application. And does that, in spite of Article 19 of the regulation, have some consequences for the extent of the judicial review and the individual rights that can be deducted from the criteria of the Dublin regime? And again, you will see when you look at the Abdullahi judgment that there is, I think, a very clear answer that will allow the national judge to know what he has to do and what he should do according to European law with this case. But perhaps, again, a targeted response that doesn't widen and give a lot of obiter dicta for other cases. Because the court stressing the fact and the system of mutual recognition and mutual confidence, which is referred to in point 52 and 53 of the judgment. Then in point 60, the concluding part says that in such a situation in which a member state, after a description of a generalized description of the circumstances of the case, in such a situation in which the member state agrees to take charge of the applicant for asylum, and given the factors mentioned in paragraph 52 and 53 above, the only way in which the applicant for asylum can call into question the choice of that criterion is by pleading systemic deficiencies in the asylum procedure and in the conditions for the reception of applicants for asylum in that latter member state, Hungary, which provide substantial grounds for believing that the applicant for asylum would face a real risk of being subjected to inhuman or degrading. And then we are back in the NS and quid and so on. And then in point 61, the court says that there's nothing to indicate that that should be the current situation in Hungary. So this is what you need, Austrian judge, in order to resolve the case. And then the court closes this file and await for the next file on interpretation of the Dublin regime. And of course, for practitioners, it would sometimes be nice to have wider, broader replies, and we know that, and sometimes we also give in to the temptation to give broader replies. But this is, of course, not without dangers, because then when you get the case that is covered by your obsdicta, you sometimes realize, yes, but there are actually additional issues that should be taken into account, and sometimes you regret perhaps that you expressed yourself too broadly in the first or second case in an area. So what is the conclusion of this? If you go up a little bit in the helicopter, I would say that first of all, the court treats cases in these areas, including asylum in Dublin, in the same, basically the same manner, with the same diligence and the same fashion that it treats other cases. So if there is a competence for judicial review, it is applied in pretty much the same style as in other traditionally community union areas. There is a link between mutual recognition and mutual trust, and there is a presumption that other member states live up to their essential obligations in this area, but it is only a presumption, and you cannot, as a requested member state or the one who has an asylum application before it, blindly rely on this presumption. It may be challenged, it may be falsified, and if there are evidence that points to a systemic failure, then there is an obligation to investigate and clarify the situation. But the presumption is recognized both by us in Luxembourg, but also by our colleagues in Strasbourg. And as demonstrated by Prit and Abdullahi, yes, we are also in this area reluctant to broaden our judgments, I would say, too much. We give a general interpretation of union law, but normally targeted to assure that the current situation before the national judge can be resolved, that the interpretation we give on general European law can be applied by the national judge in a way that allows him to solve the case before him. But we hesitate to go very much further. And that is it's not a rule or practice without exceptions, because sometimes we do go further, especially when we are tempted by the fact that we can then avoid taking a position on too difficult further questions of a case. But when we fall for this temptation, we are in a sense challenging the whole system a little bit, because we then sometimes resolve the current case actually already at the level without leaving the application of the general interpretation to the national judge. These cases also demonstrate the way in which the ECJ is concerned with fundamental rights. In a way, play perhaps a more significant role now when we have the Charter than they did before. But we still apply fundamental rights in pretty much the same way that, say, a national Supreme Court will do it and is obliged to do it. But we are not becoming a specialized fundamental rights or a second human rights court at European level. We remain and will remain also once the accession of the Union to the European Convention on Human Rights will be finalized and come into force. We will remain a general court, a European court, but a general court which, like other courts, will have to take fundamental rights in due account. But there is no question who has and will have the final say on fundamental rights. That will be our colleagues in Strasbourg. And coming back to Oscar Wilde, he, among the many things he said, is that one must always play fairly, but then he added, when one has all the winning cards. And perhaps it's not too bad that both national judges, but also European judges, including notably the Strasbourg colleagues, have taken the protection of fundamental rights just a little bit further than the Oscar Wilde starting point. Thank you for your patience and attention.